Okay, I think we're ready to get started tonight on our session titled Plea Agreements, When and Why. I'm going to introduce our moderator for tonight, and that is also another one of our deputy prosecuting attorneys, and that's Ms. Kavana Tyler. Welcome, Kavana.
Well, good evening. As Ms. Annie said, I am a deputy prosecuting attorney with the Marion County Prosecutor's Office. I've been with the office for almost about 6 years now, and currently I've been in several divisions. Used to be with Community Prosecution, but now I typically handle the unemployment insurance fraud cases. It's just a pleasure to be here with you guys tonight. As Ms. Annie said, I am your moderator, so I'll kind of be helping to manage the session as we go along tonight. Also, just a few housekeeping things. The session will be pretty interactive. If you have any questions while Ms. Katie and Ryan are up giving the presentation, please feel free to raise your hand and ask questions during that time. Also, if the session runs a little bit longer and you have questions after we conclude, then of course, if they stick around, they would be more than welcome to answer any of those questions at that time. Also, restrooms are outside the double doors across the hall. Snacks are also to your left, and please feel free to help yourself, refresh your drinks, and any of your other snacks. And we will take a quick 5-minute stretch around 6:45, so you'll see me kind of come up and tip up, give them the heads up. We'll take a little 5-minute stretch, and then we'll reconvene. And that's pretty much about it. And so we go ahead and introduce our presenters for tonight. First, we have Katie Jackson Lindsay. She's a native of Indianapolis. She's a proud graduate and alum of Northwest High School. Come on up, Katie. And the IPS school system. She did graduate in 2008 from the Indiana University Maurer School of Law, and she was admitted to practice law in Indiana in 2008. Now, Katie worked for our office from 2008 to 2013 as a deputy prosecuting attorney. And while at our office, she did primarily handle domestic violence, child abuse and fatalities, and sex crimes cases. In 2013, Katie did move on and she started her own private practice, Jackson Legal Services, PC, where she primarily handles criminal defense cases. Katie is also committed to several community organizations, including Good Samaritan Baptist Church, Visions Ministries, the Indianapolis Bar Association, the Indianapolis Alumni Chapter of Delta Sigma Theta Sorority Incorporated, and Katie is married to Brandon Lindsay. Let's welcome Katie. Next, we have Ryan Mears. Ryan is our Chief of Major Felony Division in the Marion County Prosecutor's Office. He has extensive litigation experience dealing with complex legal matters in the area of criminal law. Ryan is a veteran of over 50 major felony jury trials, including successful prosecution of high-profile murder, robbery, and drug conspiracy cases. Ryan graduated magna cum laude from Indiana University McKinney School of Law, and he can be frequently seen running around the streets of Indianapolis or at the nearest playground, and as he's an avid runner and basketball player, given his height. And Ryan also enjoys spending time with his wonderful wife, Shannon, and 19-month-old son, Thomas. Let's give Ryan a welcome. All right, and I'll turn it over to Katie and Ryan.
First of all, I want to thank everyone for coming out here today. It's nice to see so many people come out here and be willing to listen to Katie and I chat about plea agreements. And one of the things that we wanted to do tonight is really just kind of let you and everyone else know what the thought process is behind the types of plea agreements the state offers, maybe why we offer plea agreements under certain circumstances, maybe what are some of the motivations for a defendant to accept the plea agreement, what are some of the considerations that the state considers, what does the defense consider, as well as discuss what options are available to us as we try to resolve both misdemeanor and major felony cases. That's kind of a roadmap of what we'd like to explain to all of you today. So without further ado, I'm going to turn it over to my partner here, one of the finest criminal defense attorneys here in the city of Indianapolis, the great Katie Jackson.
Thank you, Ryan. Well, I'm really excited to be here because I love being a prosecutor. I was a prosecutor for, I always say for a long time, but I guess 5 years is really not a long time when you really think about it. But I'm just really happy to be here to be able to give you a defense attorney's perspective and hopefully a defendant's perspective on why plea agreements work in our system. I think that this is an interesting topic because you get a negative viewpoint from both sides. I have clients that come to me that say, I don't want a plea agreement, I'll tell you that. And I'm like, well, maybe you do, you just don't know yet. And then the community always thinks, oh, why would they resolve that with a plea agreement? They don't want to try any cases. So I think this is a unique opportunity to hear both sides of this issue. And so I, like Ryan, am very pleased to see this many people here. I was a little surprised by that number. And I'm happy to have this conversation with you all tonight.
So let's get started. I think one of the first things that I want everyone to understand and to think about when the state talks about a plea agreement, why does the state offer a particular plea agreement? I think the number one consideration that we always have in our mind is fairness. When we offer a plea agreement, we are trying to be fair to the victim, we're trying to be fair to the community, and we're also trying to be fair to the defendant. So one of the things that we constantly think about is, are we being fair to our victim, to the community, and the defendant? And that involves a variety of considerations, which we're going to get into a little bit more. But I think you need to understand that the underlying principle of what we're trying to do is we're trying to be fair to each and every single individual that we encounter. Now, that's not to say that there's going to be times that maybe we don't disagree with our victim, with the judge, with the defense attorney at times. But we're all ultimately trying to reach a resolution that's fair to all the parties involved, and that's what we strive for each and every single day. When we talk about fairness, we have to talk about what we consider in terms of trying to reach a plea agreement, and I think Katie can maybe lead us off on what are some of the things that her clients consider when trying to reach some sort of plea agreement.
I think I have a pretty loud voice, so maybe I won't need to make it. Oh, okay.
Yeah.
You need to remind me of that.
I'm sorry.
I'm nervous. Just kidding. One thing in terms of considering fairness is I always say a lot of times my clients who are arrested, they may have done something. Every now and again they did nothing. But usually they've done something, but maybe they haven't done exactly what they're charged with. So when I think about plea agreements and considering fairness, I think that's really important because when someone is arrested, you typically don't have their side of the story. When 911 is called or an officer is flagged down or however law enforcement gets involved, when they come to the scene, they usually get the victim's perspective or the eyewitness perspective, but not necessarily the perspective of the person that's being accused. So in terms of fairness, by the time we get to a plea agreement, one of the things that I make a practice of doing as a defense attorney is trying to get the prosecutor to understand my side of it or my client's position or how we got here from my client's perspective. So I think in terms of fairness, that's one of the things that we consider. One of the things that we also consider, if my client is in fact guilty, what is the appropriate remedy? How can we find a fair resolution for everyone that not only is going to bring justice to the situation or the person that was wronged or the entity that was wronged, but is also going to be of benefit to my client in such a way that they're not going to find themselves in that situation again. And we're going to get into terms of a plea agreement later, but generally the process that I go through includes all of those considerations. What really happened here? Has the state charged what really happened? What can I do to enlighten the prosecutor on where we really are and what a fair outcome is?
And Katie just brought up a wonderful point and something that I want to discuss with you guys, and that is the terms of fairness. You know, I'm very fortunate. I have the best boss in the world in Terry Curry. And each and every single day when I sit down with him and I talk about what are we trying to accomplish, the thing that I always leave with is he always wants me to do the right thing. What's the right thing to do under the circumstances? And I want to give you guys a real life example of how this played out. I had a co-defendant murder case in which we had the individual who was the shooter, who was charged with murder, and then we had the person who helped him out, who was, we were charging under an accomplice liability theory. They were both charged with murder, and we had reached a deal with the person who was not the shooter. And we took his statement, and he gave us a statement, and if everything that he said in his statement was true, that person was 100% absolutely not guilty. Now, he was charged with murder, so he was looking at 45 to 65 years, and he would sign whatever I put in front of him because he didn't want to be convicted of murder. And so we had this process. We talked with him, and I looked into what he said, and at the end of the day, I believed what he was telling me. There were other factors that made me think, wow, what you're saying here actually is probably what took place, and if what you're telling me is true, you're not guilty of anything. And so I went to Terry Curry and I told him, I said, Terry, this guy will sign a plea to criminal confinement, to battery, up to a lesser charge, but I don't think he did it. And Terry gave me the permission. He said, do the right thing. And he allowed me to dismiss the charge against that individual, despite the fact that he was willing to sign a plea agreement. And that goes back to what we try to do each and every single day, which is we try to do the right thing. We try to do what is fair and what is just. And that's kind of a real life example of that. This particular case has a happy ending from the prosecution point. We were able to charge the shooter with murder. We proceeded to trial, and we ended up getting 100 years on the shooter after a jury trial. But we got there maybe in a little bit of a different way, because the person that we were talking with, one of the co-defendants, indicated to us that he was not guilty of murder. We looked into it, and the right thing to do under that circumstance was to dismiss the charge. So it's not always the right thing to do to move forward. Yeah. Oh, no.
Ryan was totally responsible for the PowerPoint. And then he gives me the clicker when it's time to
We're off to a good start here. We're 4 slides in and we already have a technical difficulty. So when we're thinking about a plea agreement, when you're trying to think to yourself, okay, maybe we'd like to offer a plea agreement in a particular case. What are some of the things from the state's perspective, from the prosecutor's side, what are some of the things that we're going to consider? One of the first things is going to be the individual's criminal history. It's always important to consider the defendant's criminal history, what their prior life experiences have been, have they had contact with the system, have they had the benefit of probation, parole, home detention, maybe alternative forms of punishment. The defendant's remorse, that's actually a very big factor in this. There are a ton of really good people who make poor choices, who make mistakes. Are they sorry for what happened? Are they sorry for what they did? Are they apologetic to the victim? A lot of times that goes a long ways in terms of trying to get a particular case involved. Obviously, the nature of the crime is very important. You're not going to treat a public intoxication case the same way you treat a murder case. So you have to always consider what's this particular individual charged with. Another thing that's very important is the actual strength of the case. You know, when you sit down and you think about your case, at the end of the day, can I prove my case? Can I prove beyond a reasonable doubt that this person committed the offense that they're charged with? And we have a pretty thorough analysis and vetting process when we consider the strength of a case. And then the last thing on this slide is witness and victim cooperation. It is something that is a reality here in Marion County, is that sometimes our victims or our witnesses, maybe after the case is filed, are not as cooperative as we would like as we move forward. And how willing is this person to come in and testify and indicate this is what happened on a particular given date and time. One of the things that's important to remember when we're considering all these things, a lot of times the defense is presenting us with information that we can consider that help us figure out, get a more well-rounded perspective of the individual that we're dealing with. And that's something I know Ms. Jackson is incredibly effective at, and I think she's going to share a little bit about that.
So coincidentally, even though we're on the opposite side, these are almost the identical considerations that we have when considering whether or not a client should take a plea agreement. I am an attorney that I probably get on the prosecutor's nerves with this, but it's something that I always thought was effective as a prosecutor. If I have a major felony case and my client is facing potential prison time, I want to sit down and have a conversation with the prosecutor about my clients. And sometimes prosecutors will say, well, Katie, just shoot me an email. And I'm like, no, somebody could be going to prison. You know, this is serious. Let's have a conversation about it. Let me explain to you who this person is. So absolutely criminal history. If I have a client who's never been in trouble in their life, I know that when I come to that negotiating table, I'm going to be positioned differently than if I have a client who has a pending case or has a criminal history as long as my arm. And I know that the conversation is just completely different. With respect to remorse, oh, sorry. A lot of my clients, depending on you have some clients that they will never admit guilt, and with all due respect to them, sometimes they just did not do it. But when you have those that are remorseful and they want to right the wrong, you have to make sure that the prosecutor is aware of that. And I think that should go into how they are treated, because that says something about whether or not they're going to repeat that behavior. Again, exactly like Ryan said, the nature of the crime. If I have a client that's charged in misdemeanor court versus major felony court, we're talking about a different level of punishment. The strength of the state's case versus the strength of my case. I think another way that I'm probably unique as a defense attorney, I'll go and put my cards on the table to the extent that I can. I can't, breach my client's confidentiality. I can't tell their secrets or things that they've told me in confidence. But from a general perspective, I try to go to the state and say, well, listen, this is what our defense is going to be. This is what we're going to do. I'm not going to hide the ball from you, and here's how I think it's going to affect your case. So if we can reach an agreement that is beneficial to everyone, save our taxpayers, including myself, I pay taxes here in this county, save us all some money and avoid a trial, this is what I think we should do, and here are my cards, and I think that's effective as well. And then obviously victim and witness cooperation is important to us. And that's also important from the perspective of sometimes, well, all the time, as a defense attorney, I have information that the state doesn't have. And that sometimes includes information about their witnesses. Because when a witness goes and sits down with law enforcement or the prosecutor, they don't show who they really are every time. And sometimes I'm aware of these Facebook messages that they've sent threatening to kill my client before this happened, or some other dirty secret that they may have. And so cooperation is important, because obviously from our perspective, sometimes the state can't make their case without victim or witness cooperation. But also the credibility and reputation of the witness is something that we consider in terms of considering whether or not to go forward with a plea agreement. Let me go to the next one. Okay.
And just to touch on a couple of things that Katie said there, it's important to remember that we as prosecutors, I never have the option of talking to Katie's client. The rules don't allow it. And if I did, Katie would be really mad at me. And the judge would be really mad at me if I did that. So what I hear about a defendant that I'm dealing with is always going to come from the defense attorney. And that's why the defense attorney's role is so crucial and critical, is they are the one that needs to provide me with information, background information on a particular individual. Hey, this person is a really good person, here's why, and they just made a poor choice. And you can outline, they're in school, they're working, they have a young child, this would be a hardship on their family, all those types of considerations. And it's up to Katie to provide me with that sort of information so I can make a well-informed decision. In criminal justice and criminal law, it's not one size fits all. Every case is unique, and the more information I have about a particular individual, the better off I feel, because I want to make a very well-informed decision about what's going on. Some more considerations that we deal with. One is just a pragmatic consideration, witness availability. Sometimes your witness lives in Seattle, Washington. They are a long ways away. Getting them back for a trial, that's something to consider. Not everybody who's a witness to a crime, not everybody who's a victim to a crime is a resident of Marion County. We have some people here from Ohio here today. Something unfortunate happens and they're a witness and they see something, they're from Ohio. That's something that we have to consider bringing them back. That's certainly something that we consider. Evidentiary issues that develop during the trial. We file a case and then it takes 70 days, 6 months, maybe up to a year to resolve a case, depending on how complicated the case is. We're not just sitting around twiddling our thumbs, we're actually working on the case. We've submitted DNA requests. We're analyzing cell phone information. We're looking for the data that's on the cell phone. We're trying to see where the cell phone was located. We're testing for fingerprints. We're getting all that information while the case is pending. And sometimes that affects how you view a case and what type of plea agreement you're going to offer. So those are things that can develop. Also, sometimes it works the other way, as Katie pointed out. Sometimes your victim puts really bad things on Facebook, and Katie comes to me and says, well, if your victim's so innocent, why did they just say this on Facebook? Well, that's a really good point, Katie. That's something I'm going to have to consider. And with social media, that's something that we constantly have to monitor, both from our victims, our witnesses, and defendants, our defendants' family. When you get a case now, one of the first things that we do as prosecutors is we look at their Facebook page. We try to figure out who are they on Instagram, who are their friends with on Facebook, who are their friends with on Twitter, those types of things to try to get a more complete picture of what was going on. We do the same thing with our witnesses and victims. I'm not sure how familiar this audience is, but most people don't put on their Instagram name or their Facebook name Katie Jackson Lindsay. It's something a little different, maybe like KJack23 West Side would be her name. And so, if we find that, then we're saying, oh, well, why is KJack23 West Side saying this about the victim? Maybe that doesn't look so good for us. So those are all things that we consider as the case develops. One thing that's important that I want everyone to understand, and I see we have some individuals from IMPD here with us today, is we absolutely consider the Indianapolis Metropolitan Police Department's efforts in terms of investigating a case. We deal with many long-term investigations, many cases where IMPD has expended a ton of resources, a ton of manpower in trying to put a case together, trying to bring someone to justice, and we always consult with the detective prior to reaching some sort of plea agreement to get their impact, to see what they think about a particular resolution. That's another thing that has to be considered. A lot of times IMPD has really good background information as well, and they can tell us, hey, just so you know, FYI, we suspect that this person was maybe involved in X, Y, or Z. That's also something that they bring to our attention and something maybe that we can consider down the line. This is especially true, this final point, victim impact, and this is something Katie can speak to. She was a fantastic sex crimes prosecutor in our office. A lot of times our victims just don't want to move forward. You are asking a lot of times for victims to come into court in front of 14 strangers, 12 jurors, 2 alternates, plus the court staff who's ever in the gallery, and to talk about literally the worst moment of their life. You have to do it in front of a group of strangers. You have to do it in front of open court. That is an incredibly traumatic thing to do. Sometimes it has to be done. Sometimes justice requires that has to take place. But a lot of times we're able to reach some sort of common ground or middle ground where maybe we can avoid putting the victim through that. And that's something that we oftentimes consider in considering a plea agreement is we consider what does the victim think about this resolution. Would the victim be okay if this is going to resolve the case and maybe they don't have to step foot in that courtroom? Maybe they don't have to confront the worst day of their life. And that's something that we consider pretty heavily in terms of how we're going to maybe potentially resolve the case. And I know Katie can speak to that as both a defense attorney and a prosecutor.
I think that's extremely important, and it plays a lot more into the defense side of things than I realized before I was a defense attorney. As a prosecutor, absolutely. I dealt with very victim-sensitive crimes, from domestic violence through sex crimes and child abuse when I left the office. And anyone who has done any of those types of crimes, or really, I would think any prosecutor can tell you that's one of the hardest parts of your case is, making sure that your victim is pleased with the outcome, because sometimes based on these other considerations, you do end up reaching a resolution that they're not 100% happy with, but you always work toward a goal that at least they can live with. As a defense attorney, as you can probably imagine, a lot of crimes that happen are between people who are in some way intimately connected. I don't know the numbers on this, but I would assume that the majority of crimes that happen don't happen between complete strangers. And so I often get clients who are related to a victim or related to a witness, and that more often than you would ever realize goes into my client's consideration as to whether or not they want to accept a plea agreement as well. I've had clients who are in situations where their children are witnesses, and they say, I don't want my kids to have to come to trial and testify. If I could get something, that's not going to make me lose my job, that's not going to keep me from ever getting a job in the future, then I'd be happy to resolve this so that my kids don't have to go to court. Same thing with neighbors, the same thing with coworkers. I don't want my coworkers to have to pick a side. Let me know what I can do to try to resolve this. So interestingly enough, that absolutely is another one of those that comes into play on both sides. evidentiary issues. So I'll probably say this 10 times tonight, but it's something, when I became a defense attorney, one of the things that I was most excited about was I wanted to know what their story was. As a prosecutor, I'm really nosy. And so I just want to know everything about a situation, and I'm really thorough and meticulous. So I want to know everything I could know. And as a prosecutor, that was always frustrating for me because we never know what they have to say unless the defendant testifies. So when I became a defense attorney on that Friday afternoon, Monday morning, I was just ready for somebody to tell me their story. True story, like that's the truth. But then the hard part is you can't tell anybody else. Like my husband's here and he'll tell you that if I'm preparing for a trial, he's like, well, what's he gonna say? I'm like, I can't tell you because I'm not allowed to tell. But that's a big part of why plea agreements happen. It's because if a defense attorney is willing, or if a defendant is willing, you come to the table and now you have the full story, which causes new evidentiary issues. Like Ryan, I have a real life situation where I was representing a 17-year-old kid that was charged with murder. He was from Atlanta, Georgia, and he was just here on Christmas break visiting his grandmother. And like I said, when I first stood up here, usually my clients have done something. Is it a crime? Maybe, maybe not. And if it is a crime, maybe it's a lower level crime than was charged. But this is one of my clients that I was convinced he did nothing. He did nothing to get himself here other than visit his cousin's friend over Christmas break. And he had been accused and charged with murder. And I think the state knew that it was a pretty weak case for them, but they had this one eyewitness that said some things that just didn't add up. And so as the case is going along and he's missing his senior year of high school, every time I go visit him, he's like, Miss Katie, when are you going to get me out? And I'm like, I don't know that I'm going to get you out. I mean, that's a hard conversation to have. You know, we have to go to trial and 12 people are going to decide. Well, his mom, not even thinking of this, found this Facebook message that she had exchanged with her sister, who is my client's mom, in Georgia at the time, saying that her son, my client, had called and said how cold he was and he was ready to come back home to Georgia because it was one of those ice storms that we had in January of 2013. And he was really cold and he wanted to go home. And so his aunt responded and said, well, that's because he's outside helping the neighbors get their car out because it's stuck. And there was a timestamp on that message. And they were in another county. And so based on that, we could go to the prosecutor's office and show them, hey, I mean, we don't have a video camera that can show you that he's there, but we have a timestamp on a message that was exchanged saying that these boys are out shoveling the snow. And so the state has now charged murder. That's a big deal. Someone has died. They have that family to answer to. But with further investigation, that one piece of evidence, they were able to corroborate our evidence, and that just pulled the case completely apart and resulted in a dismissal. So the problem that we have, I think, in this county is that you hear these stories on the news. Someone was murdered. These are really bad people. Take them to jail. And then the next thing you hear is, oh, the case was dismissed. The state did a horrible job. They're just letting criminals go. Well, you don't get to hear all of the in-between and the things that really happen because that doesn't really make great news all the time. So I would 100% join in with Ryan in saying, you know, sometimes these things develop, and we are very lucky. I'm not just saying this because I work for Terry, but we're very lucky in this county to have a prosecutor who advocates for that. I mean, you find out what happened and you do the right thing, and I think that that's something that this office is really good at.
It's certainly something that we try to do, and I think another important thing to point out is when we talk about evidentiary issues that develop is, you know, when you deal with a fantastic defense attorney like Katie Jackson, she's going to file a motion to suppress, and a lot of times we get rulings from the judge where the judge maybe rules against us and a particular piece of evidence is excluded. Maybe a defendant wasn't properly Mirandized, meaning the police didn't read them their Miranda rights prior to their confession. The confession is excluded. Those types of things do happen. They don't happen on a regular basis, but they do happen at times, and sometimes that can kind of throw a monkey wrench into what you're trying to do in terms of resolving a case or changes maybe your posture in negotiating a particular case. So when we talk about a plea agreement, a number of things that we have to hammer down. It's important to remember that in almost any case, everything is open to negotiation. The only thing the statute does is sets the minimum and maximum penalty in a particular case. Everything else, Katie and I, we're free to negotiate, we're free to talk about, and we're free to try to come up with a particular resolution. So if you're charged with an A misdemeanor, the minimum sentence is nothing. It is 0. The maximum penalty is 365 days. Those 365 days can be at the Department of Correction. They can be on work release. They can be on probation. It can be completely suspended. Those are things we need to talk about. Restitution. We, as the state, oftentimes ask for restitution when we have innocent victims, meaning that if you're the victim of a burglary and they kicked in your door and stole your laptop, we're going to ask for restitution for your door and for your laptop. Those are all things that we'll ask for that would be part of the plea agreement, in any sort of plea agreement that we would offer. One of the most important things is no contact and stay away orders. If a defendant is sentenced and it looks like they might be getting out of jail, oftentimes one of the biggest issues for our victims and our witnesses sometimes is we need something on the books that says this particular individual cannot have contact with you. You cannot contact Katie Jackson if you're released, if she's a victim or a witness on a case. That's oftentimes very important for people. And those can last the entire sentence. So if a judge sentences you to 8 years, and those years are going to be served on community correction, home detention, that entire time that you're on home detention, you cannot have any contact with Katie Jackson. If you do, it's a crime. It's a separate crime, and I can file additional charges. That's a wonderful thing to give victims peace of mind as we move through this process. One of the most important things that we can do is community service, especially in the misdemeanor and the lower level felony courts. We very oftentimes ask for community service. Individuals are maybe indigent, they don't have the money to pay people to make people whole, but one thing that they can do is they can do something good for the community. They can do something positive for the individuals who are in the community, and that's something that we oftentimes make as a part of our plea agreement. And the final thought is, if Katie and I can't agree, which sometimes happens because she's disagreeable, she can just plead open to the court. She can say, the heck with the prosecutor, I don't care, I don't like his plea offer, my guy's just going to come in and plead guilty, and we're going to leave all the terms open to the court, which happens from time to time. When we're unable to reach an agreement, maybe she thinks I'm being unreasonable, maybe my victim's being unreasonable, maybe we're just not able to reach a plea agreement, and she thinks, you know what, I think I can get a better deal from the judge, so I'm just going to come in here and I'm going to plead open. The one thing that I always try to stress to people, especially in the more serious cases, is I never want to make plea agreements like buying a car. I don't want you to come at me and I say, all right, well, I want you to do 6 years at the Department of Correction, to come back and say 4, and then 3, and we kind of have this back and forth, because it trivializes the process. One of the things that I have to do as a prosecutor is I have to let the victim know what I'm offering and why I'm offering it. And so I try to be pretty firm on my offers for the most part. I know in the lower level courts that happens a little bit more frequently, but in the major felony courts we don't have nearly as much going back and forth, just because you have victims who are involved in very, very serious cases, and they don't like the idea that their case or situation, this very traumatic event that happened to them, is being treated like someone purchasing a car. And I'll let Katie speak to some of her negotiating tactics. You never want to play poker with Katie Jackson.
And I don't like playing poker because I often tell my clients there's this myth that goes around the jail. There's a lot of myths that go around the jail, but one of them is that the state's going to give you 3 offers and that third one is going to be the best. And I'm like, no. I work there. It doesn't work that way. We're going to sit down. We're going to discuss this like adults and professionals. And if I come to you and tell you this is the end of it, then you need to believe me. But one thing that I always consider before I go to the negotiating table is, what are the terms under which my client can succeed? By the time I have reached the point of negotiating a plea agreement, I'd like to believe that I know my clients pretty well. I've spent quite a bit of time with them. When I first meet them, I explain the process, and I tell them, with looking them straight in the eye, I'm not going to tell you to plead guilty until I feel like that's your only choice. Because they have to trust that I'm working on their case and I'm making sure their rights weren't violated and doing all those things to make sure there are no evidentiary issues like Ryan mentioned before. And so when I sit down and I talk about a plea, I'm not going to sign my client up for something that I know they cannot succeed. I have, quite frankly, some clients that I know they won't make it 2 weeks on probation. Every time they come to my office, they smell like marijuana. So they're probably going to keep smoking, they're going to get a dirty drug test, and then they're going to go to prison. And so I have to be honest with those clients and say, be honest with yourself. They're offering you, and this is on a misdemeanor or a level 6 felony case, the lower level felony, they're offering you to do 2 years of probation. If you get a dirty drug test next week, which you're going to, then you're going to end up doing those 2 years in prison anyway. So let's just cut out the whole middle part and let's just have you go ahead and do 9 months in prison and get this behind you. And I do honestly have those conversations, and I think that I probably can have those conversations because they trust me from the outset. I go see them in the jail. I call them and follow up on their calls. And so I'm thinking about that. What type of client am I dealing with here? If we agree to put them on home detention, are they going to stay home? Are they going to sneak out? Like, what kind of client are you? If I put you on alcohol monitoring instead of putting you on home detention and alcohol monitoring, are you going to have a drink at your house on Saturday? So I have to really consider what is going to work for my clients with respect to what is available to me, and then also what's reasonable. I have a client right now that's in the jail on a pretty high profile drug case, facing a lot of time, and when I went to see him 2 weeks ago, he said, can you give me a year DOC? Can you give me a year in the Department of Correction? No, I can't. Well, can you just ask? Sure. And they're going to tell me no. But it takes some time to get to that point. So I really pride myself on, being really informed about all of the options that are available to us, what's going to work for my clients, this type of client in the past, what hasn't worked for them, and explaining to them what the consequences of this are going to be. Because I think the other side of it that the general public doesn't get to see is, yes, we reach these plea agreements, but there's teeth to these plea agreements. If they don't abide by them, they could be facing more time, they could be facing additional crimes, further penalties. And so my main focus when I go to the negotiating table is what's fair, as we've already talked about, what's going to be a reasonable counter offer to the state, and what can my client actually do, what's reasonable for my client.
And I think Katie hit the nail on the head. When we talk about fairness, I started this off by talking about fairness to the defendant. I want to clear something up for everyone, just so everyone understands this. The last thing any of us in the courtroom want to see, the defense attorney, the prosecutor, and the judge, we never want to see that person again. We don't. And so we are looking for a plea agreement. What can we do to make sure that we don't have to see this person again? And many times we're looking for a resolution. As Katie pointed out, there are some people who are just not going to be able to comply with home detention. They're just not going to be able to do it. They're not going to stay in their house. I know it, Katie knows it, the judge knows it. We are setting that person up to fail if we put them on home detention because they're going to violate, and then they're going to get more time in the Department of Correction. So when we talk about being fair to the defendant, we think to ourselves, what can we do to make sure that we never see this person again?
And I'll add to that, often the state and the defense attorney get together to put things in the plea. Like Ryan said, everything is up for negotiation. So we may add something to the prosecutor. Sometimes, quite frankly, says to me, your guy is not going to be able to do that. And I say, well, he said he is. And so we may add a term to the plea that says, for the first violation, you're going to get 10 days in jail. For the second one, you're going to get 20, and then you're going to get 40. Or sometimes it says you'll get full backup time in the Department of Correction for any violation, just to hold them accountable. And sometimes the clients are like, well, that's really unfair. Well, you wanted this. If you can do it, let's just show them you can do it.
One of the things that I think people maybe don't necessarily understand is the number of options that are available to us on placement. So the Indiana Code was recently revised, and pretty much everything, nothing with the exception of murder and certain sex offenses, require you to go to the Department of Correction. So it used to be if you committed an armed robbery, you had to do a minimum of 6 years at the Indiana Department of Correction. No questions asked, don't pass go, don't collect $200. you are getting your 6 years at the Department of Correction. That's no longer the case. Maybe that's a good thing, maybe that's not, but that's the decision the legislature made. So when we come in to negotiate now, everything, including placement, is up for negotiation on almost all cases. And so where can we put a particular individual? Well, we can put him in the Department of Correction. I think everyone's familiar with the DOC. We have a work release facility. That's where you essentially stay the night there during the day. You're free to pursue a job. You're free to get a job. That's an option available to you. There's home detention, where you are electronically monitored, where you are told, hey, you have to stay in your house, but you can leave to work, to go to church, go to the dentist, doctor, visit your attorney. All those options are available. GPS monitoring, a lot of cases that are very victim sensitive, where we tell a defendant, you're going to be released, just stay out of this area. Stay away from the victim. We have GPS monitoring, that's available to us. The Crane House and the Theodora House are two different kind of alternative placement locations that take into account women who maybe have families who are trying to transition. Those are more transitional housing options. Those are options available to us. And then there's just regular probation, where you meet with the probation officer once a month, and the terms of probation can vary. If you're on a drug offense, you're probably going to have to go to drug classes. If you're on a domestic violence case, you're going to have to go to domestic violence counseling. If your anger management classes are available, all sorts of different options are available. And the level of scrutiny, substance abuse, absolute substance abuse evaluation and treatment. And the level of scrutiny, we also have mental health probation, where individuals who have mental health needs can receive mental health help through probation. We also have what's reporting and non-reporting probation, so the level of scrutiny that the probation department is going to provide to you varies a little bit, and that's also something that we can negotiate. As I look at all these options, it's amazing to me that we ever agree to anything, get anything done, but somehow we're able to resolve cases, and I'll let Katie talk a little bit about that.
I would add, in terms of placement, this is another point where it's important for the defense attorney to bring things to the prosecutor's attention. I've had, with respect to Crane House, I've had 2 clients in the past year who were arrested on warrants when they went in the hospital to give birth. And so they literally delivered their baby, and they allowed them to stay there with their baby, however long that takes for the baby to transition home with someone else. And then they went into the Marion County Jail for violations. Both of them, ironically, were home detention violations, where they were on home detention. They were afraid. They got a call from their case manager that they were going to file a violation, and because they were pregnant, they cut those bracelets off. They were like, you're not going to find me. I'm not going to jail while I'm having this baby. And so some of the hospitals check for warrants. And in both situations, both of these ladies were whisked off to the jail, and then they have to appear for these hearings in custody, and the court has to decide what to do with them. Well, they've already been given the benefit of home detention, and they cut their bracelet off. And so even as a defense attorney, it is almost impossible for me to stand in front of a court with a straight face and say, Judge, send her back to home detention. She won't cut her bracelet off. Because she did. And so I'm very honest with my clients about that. This is not an option for you. We're not going to do this. Because if we do this, it looks insincere. You look like you're showing no remorse for your actions, and you're going to end up going to the Department of Correction. So let me research and see what else is available to you. And Crane House is one of those options where my clients have been able to go there and take their newborns with them. It's not ideal, but it is mom with baby. In some cases, mom is nursing. So it's another option that we have. And when I've been able to put those options on the table, usually the prosecutor is a little reluctant because they cut the bracelet off. But if I can talk to them enough and say, well, look, this is my client's history, this is why they did it, this is how we got there, then usually we can get to a point where the prosecutor at least will tell the judge, well, Judge, I don't have a recommendation, you decide. Or sometimes they will agree to it outright, but that's why it's important to be, familiar with these different terms of placement. And it's also important to understand that there are progressive forms of placement. So I think in putting this slideshow together, Ryan did a good job with listing the Department of Corrections, work release, home detention, and GPS monitoring. Because if you mess up on home detention, and you have a violation for not doing something, then it's going to get worse for you when you go back. And no one wants to go to work release. I don't know why, well, I do know why, but I probably shouldn't say that. But, so you have work release, and then if you can't do that, you can't abide by those terms, then you're going to go to the Department of Corrections. So it's not always that even the court wants to immediately send people to prison. You really try to work with people to get them to the best place for them, like Ryan said, so that they're not coming back.
Okay, so let's just to give you kind of an example of some of the things that we deal with here. We're going to talk about a level 3, which is an armed robbery, which is defined by Indiana Code. And Indiana Code says that the minimum sentence that you can serve for armed robbery, which is a level 3 felony, that's our third highest category of felony, is 3 years. Now, where that 3 years is going to be served can be anywhere. It can be on work release, it can be on home detention, it can be at the Department of Correction, it could be on probation under certain circumstances. And the most the judge can give you is 16 years. So when we're in that process, when we're negotiating this plea agreement, Katie and I are sitting here and we're going to sit down and we're going to start somewhere in the middle. And then we're going to talk about placement. Are we going to do a split sentence, meaning maybe you do the first 3 years at the Department of Correction, you do the last 2 years on home detention, and you transition out. Those are all things that are open to negotiation, but if you look at this, that is an incredibly wide range that we're dealing with on a sentence like a level 3 felony, which is an armed robbery. So that's something that we have to consider. It also explains maybe why you don't see a larger percentage of cases going to trial. There is a tremendous amount of risk for both the state and the defense on a case like that. When you have someone who could potentially get up to 16 years and the state's offering you 5, maybe that sounds pretty good. I think Katie can speak a little bit more to that, and we'll get to aggravators and mitigators here in a second.
I think it's also important to point out that within that range, we have the benefit of what's called an advisory sentence. And so that gives us some guidance on where the court is going to land. On level 3, I think the advisory is 9. And so if you think about it, so the minimum someone can get is 3 years. The maximum someone can get on this crime is 16 years. But the court has this advisory sentence, which we call it, just to know where to start. And so the way that I explain that to my clients is, okay, we're going to start at 9 years is what the court is going to immediately think about when they think about sentencing you. But the court can go up to 16 years for aggravating circumstances, down to 3 years for mitigating circumstances. So if you go to trial, that's how the court's going to evaluate this. So then I talk to them and say, what are some aggravators for you? What is their criminal history like? Are there aspects of this crime that are beyond what it takes to prove the crime that's going to give you a worse sentence? For example, in child abuse cases that I have now, were you in a position of trust with this child is what we call it. Were you their parent? Were you their caregiver? And I really try to talk to my clients and explain, we could get up to 16, but the state is being fair and offering 9. But on the flip side of that, there are situations where I tell my clients, well, the state is offering you 9, but I don't really think the court is going to give you more than 5. And here's why. You've never been in trouble before. You've paid back the money on this fraud case or whatever it is. And so those types of things are mitigators. But again, I think at the negotiating level, it's important for the parties, for the prosecutor and the defense attorney, to discuss those aggravators and mitigators amongst ourselves. And that's sometimes how we get to that number.
All right, so there's plea agreements. We have a lot of options available to us. And in a plea agreement, one of the things that the defendant has to do is the defendant has to admit that they were guilty. They have to admit that they committed the crime that they are pleading guilty to. And what the judges will do, the judge will do what's known as a factual basis, meaning that if it's an armed robbery, Katie Jackson has to admit that on... Okay, Brandon. Brandon has to admit on October 10th of 2016 that he did commit robbery, which is knowingly take property from another person while using a deadly weapon. He would have to admit to those facts to a judge. Diversions are different. Diversions do not require an admission of guilt in the sense that on your criminal history, in a year from now, 2 years from now, 5 years from now, or 10 years from now, it's going to say that it was diverted or the case was dismissed. So you're not going to have a guilty conviction on your record. Those options are available to us. Once again, diversions are governed by statute. So the types of crimes that we are eligible to divert, Indiana law says these types of crimes are eligible for diversion. So for instance, I could not divert a murder if I wanted to. However, if I wanted to divert a public intoxication, I could. If I wanted to divert a theft, I could. If I wanted to divert a disorderly conduct, I could, and the list goes on and on. So that's an option that's available to us as well. With a diversion, you have a couple of options. You have to pay a diversion user fee of $302. Once again, that's set by statute. That's not something that the prosecutor office makes up. That's what the Indiana legislature decided to do. And if you do not have the money to pay that $302, we will still offer you a diversion, but in lieu of the $302, you have to do 40 hours of community service. And diversions are a really good way to resolve a lot of misdemeanor and lower level felony cases, and that's something that we routinely do here at the Marion County Prosecutor's Office. This is especially good for college students. I don't know if you know any college students, no offense to you guys, but college students are notorious for making poor decisions. And they oftentimes have possession of marijuana, they have theft cases, they have all sorts of things. And rather than getting someone's life off track permanently with a conviction, a lot of times we're able to divert those individuals. And that's something that we're able to do here in Marion County, but it's governed by the statute.
Even with the diversion, that's still something that I sit down with my clients and have that realistic conversation, because I think it's important to understand that even a diversion has teeth to it. So in this document, the first thing is that you are admitting that this crime happened. You're admitting that you did this. In a diversion, you also have to agree that in the event that you get in trouble for the next 2 years, the state can open this case back up. So I tell my clients, in a sense, it's like being on probation without the probation officer. If you get charged with something else within the next 2 years, the state's gonna bring this case back. And guess what? You admitted to these facts. So that's an issue. You waive your right to be tried within 1 year because they can bring it back in a year. And then there are other things that come along with a diversion besides the fee. For example, if I have a client that is charged with possession of marijuana and they've never been in trouble before and they're offered the benefit of a diversion, then they have to go to a marijuana education program on one Saturday, and they have to pay $85 for that. And so I have a reputation of being kind of like a mom on my clients about diversions, because they have to understand that, you know, if you don't abide by the rules of this, then it could still come back at you. The other thing is with respect to the community service. I'm really, really hard on my clients about community service. I tell them, when you give me a letter, I am going to call to find out if you actually did the community service there. Because if you didn't, and you have a gun-ho, brand new, just passed the bar, ink still wet on their licensed prosecutor, and they call to find out if this community service is real, and they find out that you have forged a signature or you have created some service opportunity, now you're gonna get charged with forgery. You're not gonna get a diversion. And so it's important to understand that while this is an agreement to withhold prosecution, while it is an opportunity to go back to your clean slate, at the same time it has teeth to it too, and it's something that can't be entered into lightly.
You know, as we, oh, sure.
Can you go back a few slides now? So tell me about this code again. You said for a level 3 felony armed robbery, minimum 3 years, maximum 16 years, that can be served anywhere. You're telling me an armed robbery, they could get home detention?
That is correct. So the way the law, yeah, the way the law used to be, as I kind of started this out with, was it used to be you had to go to the Department of Correction. Absolutely had to if you used a deadly weapon during a robbery. That's no longer the case. So now it's up to the judge's discretion, the prosecutor's discretion, in terms of offering maybe some sort of alternative placement.
Why would you do that?
Well, a lot of times,
It's a violent crime against a person.
I wish, can we get you elected to the legislature?
I need to understand.
Yeah, couple of different things on that. You know, a lot of times on these types of cases, we don't agree to community corrections. So what we'll do is we'll do what's known as an open plea. So I'll say, Katie Jackson, your client I will agree to a cap of 8 years on the sentence. We're going to leave it up to the judge. I'm going to argue the aggravators and say this is why the person needs to go to the DOC. Katie's going to say here are the mitigators, this is why this person needs to be placed on home detention. And that's how the majority of these cases are resolved. And so sometimes, what's that?
And they end up in DOC.
A lot of times, yeah, despite the fact that the judges have this discretion, a lot of times at the end of the day, the person ends up in the Department of Correction. If you ask, why would the state of Indiana ever agree to that on a particular armed robbery case? Unfortunately, sometimes the cases just turn out to be not great. And we're left with a scenario where if the person says they're willing to plead to home detention and we went to trial, we don't necessarily like our odds at trial because of a variety of different factors, then maybe at that point, maybe we're able to, we're a little more willing to agree to home detention. I think Katie had a couple thoughts she wanted to
It's
share.
not a good case, you're saying, because this isn't a victimless crime.
Right.
This is a violent crime against a person. So at what point would you say home detention? I just want to understand this, because I'm blown away that you can get home detention for holding her up at gunpoint.
Well, if someone held her up at gunpoint, I'd file a visual. But no, the situation.
Bad example. But
Right. No. Here's a lot of times, unfortunately, our victims are also our defendants, and sometimes our victims are maybe not doing. They're not maybe necessarily serving the community well at the time the robbery took place. A lot of our robberies involve individuals who are, quite frankly, engaged in the trafficking of drugs. And a lot of times what is stolen is drugs. And sometimes the community is not real sympathetic to drug dealers who get robbed. That's something that we deal with on a daily basis. That's something that maybe you have a victim who is also your defendant who's sitting in the jail, and maybe they're not exactly enthusiastic about coming in and testifying against the person who robbed them of their drugs. So that's one scenario that we deal with on a pretty regular basis.
But I kind of agree with Nikki, because I really think that the victim in that will be when that person, there's no way someone can stay in their home for 3 years. I mean, I love my weekends, but there's no way I'm staying at home for 3 years. But the victim will be the next person that gets killed. Not, I mean,
Can you say what you said, please?
Yeah, we couldn't hear.
I said that the victim will be the next person, when that person doesn't stay in their house for 3 years or 8 years, the victim is the next person, because that person will probably get killed in a robbery. Next time around.
I think armed robbery is a good example of one of those crimes where the case could really fall apart. So when we think of armed robbery, the first thing that pops in our mind is this really heinous situation where this guy comes in with a mask on and goes right up to your back and says, "Give me all your money, I'm gonna shoot you," and there is a bullet in the gun. Well, that's not always the situation. I mean, I've had cases where my client was charged with armed robbery based on the assumption that my client had a gun. And so he goes into the Boost Mobile with his hand in his pocket and wants you to believe that he has a gun. But there's an evidentiary issue. Can the state really prove that that was a gun in his pocket versus a pack of Starburst? I mean, only I know what, my client would say if he went to trial. And then there's the situation of, can you actually identify the person? Armed robbery is a good example of that. Usually, armed robbers are wearing some sort of mask or hooded sweatshirt, or it's just really dark in an alley, and so you can't really see them. And so I think that's a crime where ID is an issue for the state, and that's something that I, as a defense attorney, am going to exploit and use to negotiate a plea for my client. I think in the grand scheme of things, at least in this county and in the surrounding counties, it's probably a lot worse. Typically, I've not been able to get a situation where I plead my client open to the court and the judge sends them to home detention for a heinous armed robbery. And usually if facts come out later that suggest that maybe it wasn't my client, or maybe it wasn't an armed robbery, or maybe there was something else going on, that's usually a situation where we're trying to figure out what is appropriate for them to plead to. So I don't want to leave you guys with the impression that there are armed robbers on home detention, but it is possible.
Doesn't the cost of courts and the president have something to do with it also?
From the prosecutor perspective, no. From the legislative perspective, yes. And, you know, just recently, the Indiana Code was really changed, fundamentally changed, and we being the Marion County Prosecutor's Office, were against a lot of those reforms, this being one of them. I could give you example after example of crimes that were non-suspendable, meaning you had to go to the Department of Correction, that are no longer non-suspendable because the legislature was concerned about the number of people we were sending to the DOC. We, as the prosecutor's office, thought, like, well, if you rob someone with a gun, you deserve to go to the DOC. And that's, yeah, like I said, I'll put a sign in my yard for you. I'm with you, 100%. And unfortunately, that's not the only example. There are other examples that I could go into as well, but it is kind of the current state of the law here in Indiana. Does anyone else have a question on the sentencing scheme? Yes?
The length of time, I'm allowed.
I know that's new.
The length of time that a witness has to wait. I have gotten 1, 2, 3, 4 letters and a visit from the police that the thing that I am witnessing is going to be held over. Now, it was supposed to have been July, then it was supposed to be October, then it was supposed to be September, now it's November. All that time that he was on an ankle bracelet, which is worthless as two.
Don't.
I'll have to clean that up. It's worthless. Worthless. Because I can go in there and go click, click, and the daggone thing's gone. So, those are worthless. That's the waste of Indiana's money, our policemen's money, our prosecutor's money. And he, of course, busted probation. They stuck him in jail, and he's still in jail. This is I think it's a capital crime, but I don't think it's going to be held as a capital crime. He killed a mother and a baby in an accident in front of my house. Now, as far as I'm concerned, the boy should be decapitated someplace. But nobody, that would be against the rules. Now, my way, I let his wife pregnant, the baby, and died.
Well, let me repeat this, a couple of things just so everyone can hear. One of her questions, I think the initial question was essentially that cases have been, she's a witness on a case, and it's been continued a number of times. And I guess just to address that, you know, one of the first things when I meet with victims, when I meet with witnesses at the outset of a case, I tell them there's one thing I have no control over, and that's the court's calendar. We really are at the mercy of the court. There are literally thousands and thousands of pending cases right here in Marion County right now, and there are 6 major felony courts, and what you described is a major felony. We try jury cases pretty much every single day here in Marion County to work through those cases, but because we have so many cases and so few courtrooms, these cases do have a tendency to linger and last longer than what I think people think that they should. She also gave the example that this particular individual was involved in a case, sounds like a car crash where someone died and that they were on home detention. You talked about armed robbery being a case that those charges change. Same thing on DUIs causing death. Same thing on DUIs causing serious bodily injury. The law was, it was a C felony, or where your range of penalty was 2 to 8 years. If you were involved in a car crash and you paralyzed someone, you could get 2 to 8 years. Now it's 180 days to 2.5 years, because that's what the legislature decided to do.
I may not be around.
Well, I hope that's not true.
Credit for time served, is that part of the negotiations, or how does that work?
No, we are, the question was what kind of jail time credit do individuals get? That is also governed by statute, so I have no control over that. Katie has no control over that. The judge has no control over that. So for each day you served, you get basically, it used to be you got day for day. So if you served 1 day, you got 2 days. Now it's essentially 75% for most offenses or certain crimes that are 85%. But for the most part, that's across the board.
Is it the legislature that's doing this? Is it our government that's doing this?
It's the Indiana legislature who are making these decisions.
Do you think a couple of old rods could start? We've got the city of Indianapolis already knows it. You think we could start maybe a problem and start sending letters?
I believe in the power of the people. Yeah. Yes, sir.
First, I just want to say I prefer, if you could, just for cultural reasons, if your office could think of 20-somethings versus college students, because some people who aren't in college should get the same break if they're 21, 20 years old as a college student. I want to know what the effect on if you do a background check, if you successfully complete your plea versus successfully complete the diversion, because you said you could plead not guilty or something to it. So when you do a background check 10 years later, what's the difference that'll come out? And then the Crane House, I'm not sure how that paid for. And then the last thing is when they're charged with something and then they're dismissed, is there a way you can tell me the percentage of charges that are dismissed with a public defender versus with a private attorney?
Well, just going for the first thing on the college example, diversions are open to anybody, not just college students. I just wanted to give the IUE students who are here a hard time. Certainly, anybody.
You understand what I was talking about? That a 20-year-old, whether he's in college or
No,
not college, he still make the same youthful mistake.
Sure, no, and probably the better way to describe that would have been, young people who make mistakes. We certainly want to give them the benefit of the doubt. Now, if you go one step further, even people who are a little bit older, they can sometimes make poor choices, and we want to give them the benefit of the doubt as well. It's certainly not limited by education level or even age. Certainly the diversion program is open to all different types of people, and there's no requirement on that. You want to, the Crane House, how are those, like the Crane House and the Theodora House, those are funded by us. Yeah, there are fees associated with those residences, as there's fees associated with work release. But they're, for the large part, they're not self-sustaining.
That's something that I wanted to touch on because of the prior comment about what it's costing taxpayers. For every form of placement, with the exception of the Department of Correction, there is a fee that the defendant pays to be a part of that. The reality is, a lot of times, it's unaffordable. For example, I think home detention, now we're at $14 a day. And so a lot of times it's unaffordable for the defendant, and they end up with a civil judgment that goes onto their credit goes onto their credit report once their case is finished. But there is some accountability from the client as well. With respect to your question about what does it look like on your criminal background check, so a diversion, if the defendant completes all the requirements of a diversion, at the end of the case, the state will decline prosecution and dismiss the case. So it would go on the client's criminal record as an arrest that was dismissed. And with respect to our record expungement laws, that is like any other arrest that resulted in a dismissal. A year after the date of the arrest, it can be expunged from your record completely.
But a plea agreement where you plead guilty, that cannot be expunged.
It can be expunged as well. There are different requirements for different levels of charges.
You also brought up a good point about public defender versus private attorneys. We are very fortunate here in Marion County because we have fantastic public defenders. I don't have numbers breaking it down between resolution with public defender as opposed to private defense attorneys, but we have excellent public defenders here in Marion County. We're also very fortunate because we have fantastic private defense attorneys like Ms. Jackson and others who do a fantastic job of representing the clients. What's that? Okay. I was told that we just want to touch base on this last slide and then we'll open it up to questions. Just wanted to give you guys a little overview of what we're talking about here. So we filed 3,488 major felony cases from January 1st to September 1st. A major felony is anything level 5 felony and above. So that's level 5, 4, 3, 2, 1, as well as murder cases. And we resolved Some of those cases are going to be resolved with dismissal. Some of them are going to be resolved with plea agreement, and then we have jury trials and bench trials. When I did this, we had done 102 jury trials. So if you look at the percentage of cases that actually go to jury trial versus the percentage of cases filed, most cases are going to be resolved with a plea agreement or a dismissal or possibly a bench trial. And then the last number is something that I think speaks to what some of you guys have mentioned here today, and that's, when we place individuals on alternative placement, when you give individuals the benefit of the doubt, which is what the statutory scheme kind of calls for. And some of you, I think, were kind of surprised that someone who committed armed robbery ends up being out on home detention or has the opportunity to be on home detention. And that brings us to our final number. We have 204 current pending murder or attempt murder defendants. 72 of those individuals had prior pending cases, meaning that they were released at the time that those offenses took place. Just things to consider as when you hear talk about criminal justice reform and things like that. Before we go back to our question, just another thing I wanted to say, anytime that you do one of these things, you're always nervous a little bit, but it helps when you have someone who's smarter and more talented than you. I want to give it up for my partner here, Katie Jackson. She did a great job. Give it up for Katie Jackson. The other thing is I wanted to thank all of you guys for your questions. They've been fantastic to this point, so if you guys have any questions, we are certainly here to answer them or try.
What is can you give me an example of a level 5 felony?
A level 5 felony?
Yeah.
A level 5 felony can be a burglary of, let's say, a business. That would be an example of a level 5 felony. A theft over a certain dollar amount. Oh no, that's a D felony now. Battery with serious bodily injury would qualify as a level 5 felony.
How many levels are there?
There are 6 levels of felony. Level 1 being the most serious, level 6 being the least serious, and then we have misdemeanor charges.
How do you have the levels and then you have like Class A, Class B, what's the difference?
Sure, with misdemeanors you have A, B, and C misdemeanors, and then felonies are levels. So with felonies it's level 1, 2, 3, 4, 5, 6, and then misdemeanors are A, B, and C. A misdemeanor being the highest level of a misdemeanor, maximum penalty on that is 1 year.
And what you may be confusing that with, under our old code, it was Class A, B, C, and D felonies. That is no more. So now all of the felonies are levels and all of the misdemeanors are classes.
When did that change?
2014, July of 2014.
I'm curious what your inspiration/motivation was to switch from the prosecution to the defense.
This is an excellent question.
Well, that's a hard question to answer with Terry Curry in the room. Because I love him like he's my uncle. And I often tell people the hardest part of leaving that office was going and telling him that I was leaving, because he is a great boss. When I first decided, I decided to be a criminal lawyer when I was like 5. And so when I was in law school deciding which way to go, I had this great opportunity to do an externship with the prosecutor's office. And so I was gung-ho prosecutor all the way. I loved it. I never thought I would leave there. We made jokes that there's a fantastic prosecutor in the office that's been there for years and I wanted to be her. And so in doing sex crimes cases and child abuse cases, quite frankly, it started to wear on me a little bit, honestly. And so I really wanted to try something different. I wanted to see what it was like on the other side. And there was also this idea of business ownership that kind of intrigued me. Being my own boss, even though I had a great boss, and one of my other bosses is back there too, had wonderful supervisors, wonderful co-workers. I just really wanted to try something different and see if I could be successful on the other side, kind of, have a little more freedom. And my husband, who was my fiance at the time, he was like, you work 80 hours a week and you're really stressed out about this. Why don't you try something else? And so it was the idea to try something else. And I will say, I equally love doing the other side. I never thought I would say that. I really do. But we often talk about if I ever want to go back, I hope they would open the doors for me. But it's not in the plans at this point.
So the lesson from that is we're going to blame Brandon.
Could you quantify the costs of a case going to court versus a plea bargain?
Sure. The question was, can you quantify the costs of going to trial as opposed to a plea agreement? A plea agreement is way cheaper. Obviously, we're not bringing in members of the community. There's no cost on IMPD because we're not paying overtime for police officers to come in to testify. There's no burden on the crime lab because those individuals don't have to come in and testify, pay those individuals overtime. It's certainly way more expensive to try a case, especially your more complicated murder cases that are going to last a couple of days or up to a week.
Do you have like a per day cost?
No, because the cases vary so much. It's difficult to quantify. Certainly, we have tried cases that are pretty expensive, but I don't think we're able to really break it down. Go ahead.
What does your caseload look like?
Our major felony deputy prosecutors have anywhere from 60 to 75 open cases at a time. That would include murders and attempt murder cases as well. So it's a pretty significant caseload. Those cases, depending on the court, turn over a little bit more quickly. So some judges have what's known as a rocket docket, meaning they get cases disposed pretty quickly. Other judges allow their cases to maybe hang around a little while longer, and those individuals have caseloads that are a little bit higher. But 60 to 75 is a pretty rough estimate of what people carry.
Just in general, in light of the climate in the country, what are the rules in Marion County concerning evidence that are on the video cameras? What did the police officers that they carry that evidence? Is it a review board? Does the prosecutor make the decisions on what's released to the public?
You missed the first day of the criminal justice.
I know, I saw it there.
Yeah. Do you want to take that one, Mr. Curry?
Well, in a general sense, if it is a matter that's still under, actually you should ask someone who was here last week, see if they were paying attention. If it's a matter that's still under investigation, first of all, let me back up. The IPD does not wear body cams at this point. They had a pilot project where a select number have done so. Up until now, there's not sufficient funding to equip everyone. But whether it's a body cam or business surveillance video, if it's something that's continuing under investigation, we have an obligation not to release that and to maintain it until the investigation is completed. And at which point, either we make a decision not to file a charge, or if a case is completed, then we could release that information. And afterwards, I can explain in more detail.